They give the IT, there you go.
Yep, I see it.
This conference is being recorded. Only the main conference is recorded.
All right. Excellent. Good morning. Apologies for those of you who were waiting behind the scenes, and we're having some technical difficulties, but I think we are ready to go. So I'm going to go ahead and call the meeting of the Commission on State Mandates to order at 10:13. Welcome to our hybrid meeting. For those of you participating in person, I do have some housekeeping information. On the table near the wall are paper copies of the meeting notice and agenda, new filings, a witness list. The electronic public hearing binder is also located there on a laptop. When called up for an item, the parties and witnesses will please sit at the witness tables, which will, the restrooms are located out the door, down the hall to the right, women's room across the open atrium. The key for both are on the table as you exit the conference room. Finally, please take note of the emergency exits in the room. For those participating remotely, the materials for today's meeting, including the notice, agenda, and witness list, are all available on the Commission's website at www.csm.ca.gov under the Hearings tab. When being sworn in at the beginning of the hearing and when called for an item, the parties and witnesses will please turn on their video and unmute their microphone. At the conclusion, of the item, please turn off the video and then mute your microphone once again. In the event we do experience technical difficulties or the meeting is bumped offline, we will restart and allow time for people to rejoin before recommencing the meeting. Finally, please remember to speak slowly and accurately for the benefit of the court reporter and an accurate transcript of the hearing. Okay. So before we begin, though this morning I would like to introduce, and it is my pleasure to introduce, our new public member who comes to us with some experience in public finance. Ms. Karen Green Ross is joining us online today. Karen, thank you for joining. Just a little bit about Ms. Green Ross. Before her retirement from the state, she did serve as the Chief of Staff to the State Controller, Betty Yee, from 2015 to 2022. Prior to that, she was Assistant Chief Counsel at the California High-Speed Rail Authority from 2012 to 14, where she was Deputy Director of Legislation from 2011 to 2012. And then finally, she also served as a Deputy Controller at the State Controller's Office from 2005 to 2007. Member Green Ross earned a Juris Doctorate degree from Loyola Law School and a Bachelor's of Science degree in Finance from the University of Florida, and we welcome you to the Commission. Okay. With that, if staff could please, Heather, could you please call the roll?
Sure. Mr. Adams?
Here.
Ms. Clark?
Here.
Ms. Gallegos?
Here.
Ms. Green Ross?
Here.
Ms. Nash?
Here.
Mr. Polland?
Here.
Ms. Peralt?
Here. Great, thank you so much. So our next item is item 1. Are there any objections to or additional corrections of the July 26, 2024 minutes? Seeing none in the room, either in online? Seeing
Madam
none.
Chair, I do not see any comments online.
Thank you. Also, just is there a way to pin our 2 commissioners who are online so that we can see them? I'm not sure if that's possible. Okay, IT's working on that. Okay. In the meantime, while we wait on that, are there any public comments on this item? Seeing none in the room.
I don't see any public comments on online, Madam Chair.
Okay, unless there's any further discussion, is there a motion?
So moved.
Moved by Ms. Nash. Is there a second? Second by Ms. Gallegos. Please have a roll call.
Mr. Adams?
Aye.
Ms. Clark?
Aye.
Ms. Gallegos?
Aye.
Ms. Green Ross?
Ms. Green Ross?
Abstain.
Thank you.
Thank you. Ms. Nash?
Aye.
Mr. Pollan?
Aye.
Ms. Peralt.
Aye. Thank you. So that motion carries. And now I think we are moving on to public comment.
Now we will take up public comment for matters not on the agenda. Please note the commission may not take action on items not on the agenda. However, it may schedule issues raised by the public for consideration at future meetings. We invite the public to comment on matters that are on the agenda as they are taken up.
Great, thank you. Are there any public comments on items not on the agenda? See none in the room. Are there any online?
Madam Chair, I do not see any online.
Okay, thank you. Hearing no further public comment, we will go ahead and move on to the next item, which is our swearing in. So Heather.
Mr. Adams. Oh, sorry. Let's move to the swearing in. Will the parties and witnesses for items 2, 3, and 4 participating remotely, please be sure that both your first and last names are listed on your Zoom window for the benefit of the court reporter. Turn on your video and unmute your microphone. Will the parties and witnesses please rise? Do you solemnly swear or affirm that the testimony which you're about to give is true and correct based on your personal knowledge, information, or belief?
I do.
I do.
Yes.
I do.
Thank you. Please be seated. For those participating remotely for items 3 and 4, please turn off your video and mute your microphones. Next is item 2. Senior Commission Counsel Juliana Murr will please turn on her video and unmute her microphone and present a proposed decision on appeal of Executive Director decision on rejection of duplicate test claim filing 23 AEDD-01.
Good morning. This matter is an appeal of the Executive Director's decision to reject a test claim filing by the City of San Jose on a permit issued by the San Francisco Bay Regional Water Quality Control Board. The rejection was based on the fact that the City of San Jose's filing duplicated the test claim first filed by Union City. The test claim process provides for the filing of a single test claim applicable to all eligible claimants in order to avoid multiple proceedings addressing the same claim that a reimbursable state mandate has been created. The appellant contends, however, that its filing should be accepted and consolidated with Union City's test claim because Union City did not plead a provision requiring permittees to implement best management practices related to the unsheltered and homeless, and its homeless population and costs to comply with the provision are much higher. Union City's test claim pleads all of the provision relating to the unsheltered and homeless population, as noted on the test claim form, the narrative, and in the declarations supporting the claim. Thus, the appellant's claim duplicates that of Union City's, and its legal rights and interests are protected by Union City's test claim, even if its costs to comply with the provision are higher. The determination whether the provision at issue is reimbursable under Article 13B, Section 6 is a question of law and not a question of fact. Finally, the Commission's regulations provide ample opportunity for the appellant as a permittee under the test claim permit to participate in the Commission's determination of Union City's test claim by providing written comments, evidence, and testimony of its larger homeless population and the higher costs that it has incurred, which can inform the Commission's decision through the test claim hearing process. Staff recommends that the Commission adopt the proposed decision to uphold the Executive Director's decision to reject the appellant's test claim filing as duplicative and to deny the appeal.
Thank you. All right, parties and witnesses, please state your name for the record. Ms. Winchester Nair for the appellant. Would you like to begin?
Yes, ma'am. My name's Colleen Winchester. I'm a senior deputy city attorney for the City of San Jose. I'm pleased to be joined with Reggie Nair, who is a deputy director for the city's Environmental Services Department. So if I may, I appreciate the time to respond. First off, the city is not disputing that, let me get to the point. if this commission's decision is that the city of San Jose's interests are adequately protected by Union Cities, that's certainly something we're not going to challenge. If we are adequately protected, we want to move forward. Then why are we here? Why am I appearing before the commission, and why am I taking your valuable time? Couple of things. This issue involves the city of San Jose's regional stormwater permit. They're issued across the state. This, I can't tell which slide I'm on in the presentation, so I apologize.
We don't have a slide up yet, Ms. Winchester. Hold on one second, please.
Oh.
And I think you had indicated there'd be a presentation. So give us 1 second. My apologies.
I'm just glad it's IT and not me. Sorry. Thank you. Thank you.
He's working on it. Give us just a second.
It's no problem. If you want me to just go ahead, I can move forward without it.
It's absolutely up to you.
I'll go ahead and I'll just move forward. So this commission is very, very familiar with regional stormwater permits. It's come before the commission on multiple occasions. Sorry, what?
I'm sorry, we're working on getting your presentation up on the screen.
Should be up right now.
Oh, perfect.
Can you see it?
I can see it.
Okay, that way we can. What page would you like us on?
The first slide, please. The second slide where we're talking about municipal regional stormwater permits.
Right.
And I just want to highlight that the municipal regional stormwater permits are issued by the state water board on the different regions. Next slide, please. And
thank you.
They contain significant requirements for municipalities in implementing the Clean Water Act. The beef and the dispute, and why this commission is so important, is because the question is, what is and is not an unfunded mandate? What is simply passing through the federal requirements of the Clean Water Act, or what are other areas where the city can get reimbursement either through permit fees or elsewhere, or what is in fact just simply an unfunded obligation imposed by the state on municipalities when the municipalities are not in a position to bear the burden. That is this commission's lane. It's super important. And as you can see from the cases that have come down, they've been litigated up and down the courts, including to the California Supreme Court as recently as 2016. Next slide, please. In fact, next slide, please. There is a pending consolidated action for a regional stormwater permit issued in effective December of 2009. That's a consolidated test claim with Dublin, San Jose, the County of Santa Clara, and the commission has a proposed draft decision pending. So this is very important and very familiar to the commission. Next slide, please. So what happened here? Let me just go back. The commission, San Jose is here because it's talking about getting the commission. It has taken a year to get to this point. Union City and San Jose filed a test claim. Both of them were deemed inadequate or incomplete. Duplicate and incomplete. San Jose's duplicate, both incomplete. Union City refiled, San Jose refiled, and back and forth for over a year. Why is this significant? Because once Union Cities is deemed incomplete, San Jose is in a tough position. Do you refile and protect, or do you wait until there's a final decision on Union Cities? But what's happened is over time, San Jose files extensive filing, significant effort and work in getting to this point. In the proposed decision, The proposed decision repeats, as a matter of law, San Jose's claim should be rejected as duplicative. As a quasi-adjudicatory body, it's very important that this issue be precisely defined. There's two issues here. One is what's the legal question regarding the regulation? And then second, how are the facts of this case applied to the legal standard? That's a question of law and a question of fact. Two separate issues, and super important to be precise in the decision, which it's not precise. So next slide, please. So let's start with the question of law. Everybody agrees we're in regulation. This is the appropriate regulation. And no duplicative test claims will be accepted after the first one is filed. But affected agencies that are not similarly situated, meaning that the test claim affects them differently, may file a test claim on the same statute, but must demonstrate how and why they're affected. So the regulation is really clear. We also have a question of fact. However, in the proposed decision, it inserts something that doesn't exist in the statute, and that's a meaning. So in the proposed decision, it says, meaning that the test claim statutes affect them differently. It adds language that says that meaning their legal rights and interests are not protected by the test claim filing. Meaning their rights and interests are not protected by the test claim filing. That language is not in the regulation. It's a meaning imposed into the regulation through the proposed decision. San Jose just wants to make it perfectly clear. The regulation says affected agencies may file a test claim, but they must demonstrate how they're affected differently. The proposed decision says, meaning that their legal rights and interests are not protected by the test claim. Again, the language is not in the statute. Why is that important? Is because regulations need to be amended through a public process and a hearing to ensure that they are accurately reflected. And also, if the commission is going to make a legal interpretation of its regulation, that inserting that language, that the parties, meaning other public entities, have a right to weigh in, go through the regulatory process. So that's the question of law. So next slide, please. We want to talk about the question of fact. Does provision C17 dealing with discharges associated with unsheltered homeless populations affect San Jose differently? Next slide, please. Just again, this is the provision of the permit. Each permittee shall identify and implement the best management practices to address discharges. Next slide, please. What does this mean? Examples of those actions: access to emergency shelters, provision of social services, sanitation services, voucher programs, RV sanitary sewage disposals, establishment of RV safe parking areas, formalized encampments, pumped out, cleaning services. These are significant types of requirements being imposed on public agencies in an area that is probably one of the most important, significant political, social issues pending right now. One of the most, if not the most, on areas where public entities are working very hard to address what is both an environmental and socioeconomic and significant issue. So next slide, please. So Union City's claim says it will incur costs for implementing best practices. How is San Jose's different? We've already implemented these best management practices. We know how much it costs. We know what the significance and the burden is on these types of programs. They are unfunded, but that's a question for another day. They are unfunded, they are significant, and San Jose and Union City are not in the same boat. Next slide, please. So San Jose's unsheltered population, 6,200, 70% of those unhoused are unsheltered. Union City, according to the public records, has 489. Again, if you go back and think about those types of requirements that are listed in the permit itself, housing, RVs, pumps outs, again, that laundry list, significantly different for a population of 489 as compared to 6,200. I think in the proposed decision, there's a lot of discussion that as a matter of law, San Jose and Union City are aligned. Again, if the commission's decision is that San Jose is adequately protected and does not need to participate, nor does this commission care to have the perspective of somebody implementing these regulations, I think that's certainly within the commission's lane. But what we do want to talk about is San Jose's implementation cost is over $19 million for fiscal year 22-23. Again, we believe that that's a perspective that's properly before the commission as a party. Next slide, please. So we respectfully request that the commission consider its test claim, consolidate it with Union City's for efficiency. However, at a minimum, what San Jose requests is that if language being inserted into the regulations is, well, gosh, I lost my train of that sentence, which would have been eloquent had I kept on it. But if the commission chooses not to consider San Jose's test claim and consolidate with Union City's for efficiency, San Jose proposes that this is such an important issue. Why should other cities jump through regulatory hoops, process after process after process, just trying to get before the commission, if the legal standard is as in the intended decision? Go through the regulatory process, make that clear for public entities. It's ironic that it takes so much time, effort, costs, attorneys' fees, staff time, burden, just to simply bring before the commission that the state is improperly imposing costs and burdens and attorneys' fees. I find that ironic. And I think what should particularly happen is moving forward, amend the regulations so that they're clear, amend the regulations so that so people aren't in the same boat. So, and if anybody has any questions, I welcome the opportunity to respond.
All right, thank you, Ms. Winchester. I'm not sure, it sounds like maybe your colleague is available for questions, or is there a presentation also, an additional?
No, she's just available for the substantive questions on the 19,200,000 and it's like math.
Okay, thank you very much. All right, with that, are there any public comments on this item?
Madam Chair, I do not see any online public comments.
Okay. Is there discussion from the commission? Questions? Yes, Ms. Gay.
So, two things. In the description, sorry, confusing me. It says that Union City's test claim does not plead provision C17, which I believe she referenced, which requires implementation of best management practices to control or reduce discharge of pollutants. Does it or does it not?
If I may
let
respond.
Juliana respond. Sure.
Sure.
Go
What
ahead and
is
let
it?
staff respond. Ms. Winchester, we'll go ahead and let staff respond real quick.
Oh, apologize.
Yes, it does. The city of San Jose is contending that it's insufficient because of their position, but it is completely pleaded. It is in the test claim form. It is supported in the narrative, and there are declarations on point. It is in that test claim jurisdictionally before the commission.
And she also proposes that San Jose's issues are significantly different, significantly enough different to warrant a separate filing. What is your response to that, given the statistics that she put in her slide? I don't know if we can get that slide back up.
All right. In applying the regulation, there are two types of agencies. There's the affected agency that's not similarly situated, and there's the similarly situated agency. When you're looking to ascertain which one, it's how the test claim statutes, or in this case, the test claim permit, affects them differently. The section C17 applies to both Union City and City of San Jose. They both must comply with it. City of San Jose has higher implementation costs because of their population, but the permit does not apply to them differently. Let's look at the example that she had on the slide. That would be 10 TC 020305. In that case, the City of San Jose's test claim was consolidated in because the City of San Jose pleaded a section that was not pleaded by any other test claimant. They were claiming that Section C2 imposed a mandate on the city. No one else made that claim. And so the test claim permit affected them differently. They had an additional mandate that they needed to bring before the commission, and they were consolidated in. In addition, that case was also complicated by the fact that there were 6 prior permits that were all different and would affect each agency differently. As you know, in our mandates analysis, we compare the prior permit to the test claim permit to find out what is new. Depending on what was in your prior permit, an activity may or may not be new.
May I also just add that if you look on page 25 of this analysis, that lays out the elements for finding a reimbursable state mandated program. And on the cost issue, which is factor number 4, a test claimant only needs to show that they will incur $1,000 worth of costs, period. They don't have to show any more than that to be eligible and for the commission to take jurisdiction. So the amount of money, certainly, I think that the commission would want to hear the testimony of City of San Jose and how that permit section affected them maybe differently, but legally you have a valid jurisdiction over that test claim that affects all of those eligible claimants and permittees under that permit.
And the second question I have actually highlighted the exact statement that she referenced as well, meaning their legal rights and interests are not protected by the test claim filing. So is what she suggests true, that this is not language that is
agreed that it's not language in the regulation, but you have to read the regulation with the whole purpose of mandates law and what the legislature enacted. The whole section 17500 says the purpose is to avoid multiple proceedings. We have Supreme Court cases that indicate that. That's the whole point, is that we don't have separate test claims filed by every county in the state, every city in the state. Local government should be working together when they're filing their test claims so that they know who is filing on what. There are options in the commission's regulations to file one joint test claim if the City of San Jose wanted to have party status. They chose not to do that. So you have to read that regulation in light of the whole purpose of Article 13B, Section 6. But this test claim, it's pled, the commission has jurisdiction on it. As you've seen with all the other stormwater permits that have been approved and where P's and G's have been adopted, the eligible claimants include every single permittee of that permit. So it's the same situation here. And then all of those permittees would be allowed to file reimbursement claims with the state controller's office for their actual costs mandated by the state.
all right. Mr. Hatch.
Thank you. I have great appreciation for San Jose's frustration, considering its relative size to Union City and Admittedly, the difference between 489 unsheltered folks versus 6,200 is huge. I'm just wondering, is volume alone enough to say there's an affected difference? I don't know the exact populations of Union City and San Jose, but I would imagine 400 could be a pretty good impact to a smaller community versus 6,200 in a larger city of maybe 1 million people. So I'm not sure that I understand, other than the total costs, the impact to a smaller community might be just as impactful as it is to the city of San Jose. So effectively, is there really a difference here? And again, I appreciate the city of San Jose's huge cost. As I represent at home a county of 3,000, we are always pleading to the state that our small numbers are of great impact to us, even though they're not huge numbers. So I would like to hear comments from either side.
May I mention, dovetail on that? So the commission invites comments. The commission wants to have comments from every different size jurisdiction. And at this stage with the test claim, it is purely a question of law. When the commission, if it's approved, moves to the parameters and guidelines phase, that is when you really need to have the participation of local government to identify how they are implementing that particular activity so that we can properly describe that in the parameters and guidelines. And that is a critical stage for participation of local government. So yes, you do want the participation. And even with the test claim stage, the city of San Jose has the opportunity to file comments on the test claim, has opportunity to file comments on the draft proposed decision, can come to the commission's hearing and testify and bring a witness if they choose. So they have ample opportunity to tell their story before the commission on this claim.
Again, because of the size of the unhoused versus their relative size, I guess my argument is there really a difference in how the communities are affected, or practically speaking, it could be very close to the same?
Right, so at this stage, all that we're determining is looking at the plain language of the permit. Is it new, the activity? Is it mandated by the state? Does it impose a new program or higher level of service? And is there an allegation of cost of at least $1,000? So that's it. The scope and the individual circumstances as that permit section is applied to individual cities and counties is not even relevant yet.
Other questions from commission members? Mr. Palmer.
Yeah, I do have a question for Ms. Winchester. As I understand your argument, it's effectively a matter of magnitude and not substantive imposition of activity. So you're not questioning whether what the rule forces upon Union City is any different than what is forced upon San Jose, only that San Jose's costs will be greater. Is that effectively your argument? Am I understanding you correctly?
Yes, and the difference, Union City's test claim didn't allege any costs for implementation. What it did is the provision C-17 talks about adopting best management practices and implementing them. So there's like two separate requirements in that one provision. Union City's costs are for adopting the best management practices, not the implementation of the best management practices, although they say they do plead the entire provision. And certainly we would be arguing that it protected both requirements, if we weren't here. But what we wanted to ensure, San Jose wants to ensure that both the adoption of best management practices and the implementation of those best management practices are properly before this commission. So if the commission decides those legal interests are adequately protected, then perhaps this has been an interesting legal exercise, but unnecessary. But flip it the other way is if we hadn't adequately protected the statute, if we hadn't adequately brought it to this commission's attention, would it have adequately been preserved for adjudication? The homeless, the unhoused issue impacts every single public entity, small, medium, and large. San Jose, like I said, has already been implementing these practices and have numbers for that. I would certainly argue that, and I would certainly not protest if this commission's determination that Union City protects adoption of best management practices and implementation of those best management practices are properly protected.
Okay,
Oh, go ahead.
yeah,
A follow-up?
follow-up questions.
And then I would like staff to be able to respond to.
Sure,
additional
sure.
clarification.
I do have follow-up questions then. Boil down to its essentials, your argument still seems to be that I'm picking out difference in expense associated with the activity imposed. And were that sufficient to allow the filing of duplicate test claims, wouldn't that then exception swallow the rule against duplicate test claims? Because everybody can find that I'm somehow implementing an activity imposed upon me differently, or it's going to cost me more or less than somebody else. And effectively, then the limitation to a single test claim would be completely absorbed by people finding minor distinctions and minor differences in the specifics of carrying out the activity imposed.
That's a very good perspective and point. However, in this particular case, implementation of best management practices for the homeless population, it's not just a matter of throwing somebody money. It's housing people. This is not just a degree of, if we could just throw money at the problem, I submit that San Jose would have solved the homeless problem decades ago. We throw a lot of money at this challenge, working hard to solve it. But why doesn't money just work? Why isn't it just money? It's because it's social services, it's housing, it's how do we get folks healthy and into homes permanently and ongoing. So this is not just a matter of money and a matter of dollar. It's also, what exactly does this mean? And if you look at the language of the permit, it does talk about housing. And I apologize, I don't have it in front of me, but I submit that it's not just money. This is a separate issue that involves much, much more than that. Social services that San Jose doesn't control, providing housing. It is a significant legal issue other than just simply money.
Yeah, I understand what you're saying, but that seems to be not unique to San Jose in the implementation of this permit, or in the requirements of this permit. Let me move on to my next question, or my last question here. You've testified here today, it's an evidentiary matter. You've testified here today that Union City has 489 unhoused, and San Jose has order magnitudes above that. How did you determine what number of unhoused Union City has? You're here testifying that Union City has that much, and I'm wondering what your foundational basis for that testimony is, because I'm not hearing somebody from Union City, or I'm not seeing a declaration from Union City. It could well be that Union City has more than that if you pulled this information from some publicly available source, it may or may not be accurate.
Again, so in using, apologize.
Go ahead, Mr.
Those numbers are from the homeless survey, the publicly available data on the homeless point in time count. I used the Alameda County numbers from the state's homeless point in time count, and then Union City's number from that official document and that official record. San Jose's, we have the declaration of Reagan Henniger. She's the house that's in the record. Her numbers including what percentage are unhoused or unsheltered. Those are in the declarations that are before the commission. But as far as Union City's number, I did take it from a publicly available source. The state's population. I have the citation to it. It's Alameda County.
I don't need the citation. I just wanted to then draw attention to the difference between the two items of evidence proffered. Whereas one, you have a declaration of competent witness, and second, you have an authenticated document from which numbers are divined. So I do still have then, in my mind at least, a question as to the true number of Union City unhoused, for purposes of then drawing a distinction between the relative burdens on the two cities. So that's the end of my questions.
Okay, great. Ms. Green-Moss, you had your hand raised. Do you still have comments or questions? She's working on it. Give her a second. You're still muted. Okay.
Yes.
Oh, there she goes.
Sorry about that.
That's okay.
The question I had is, I understand that Union City cured its test claim filing in late May, and so I just want to know the timing. Isn't once that happens, isn't the process for the various entities that want to get reimbursed to go through the process with the controller's office? So what's the status on Union City's test claim, and couldn't San Jose, now that that's cured, as far as I could tell, is it cured? Union City?
Yes, ma'am. It is cured. It was cured 2 days before City of San Jose was able to cure their test claim. It is currently out for comment, and it's in its very beginning stages. It will have to be go through the commission process. A mandate will have to be found. And then once reimbursable components are activities are established through the parameters and guidelines, then the state controller's office will issue claiming instructions, and all the permittees under this permit can file for reimbursement costs.
And
At
that would,
this stage, it's
that would
a
include,
legal process first.
right. I just want to check on the status of that, because since it was cured and that process begins, wouldn't San Jose have an opportunity then to, show the different amount that they would be allowed to claim?
Yes, ma'am.
So,
The matter is not proceeded to hearing yet. And so City of San Jose will have ample opportunity at the test claim hearing and at the parameters and guidelines stage to provide their testimony.
Okay, I just wanted to clarify. I understood the process.
To cure a test claim just means that their filing did not comply with one of the government code sections that identifies all the elements for a test claim filing. And so when it means to cure is that this office has determined, well, you've now met all of the elements for a test claim filing, and now the commission is taking jurisdiction over that test claim. At that point, then we send out the test claim for comment. We issue a draft staff analysis or draft proposed decision, and then we receive comments back on that. We then prepare a proposed decision for the commission's hearing. So this matter is not even set for hearing yet. It's still, the record's not even closed. We haven't, I believe we're still in the comment phase of the test claim, so we still have several more months before the commission will even hear the matter to determine whether or not there is a reimbursable state mandated program. If the test claim is approved, then the commission has to adopt parameters and guidelines which identify all the reimbursable activities, the eligible claimants, the period of reimbursement, any offsetting revenues. Once that is adopted, that goes to the state controller's office to issue claiming instructions, which just provides the notice and the right of local government to file their reimbursement claims with the state controller's office. So we have many steps before we can get to the controller's office. And at this stage, the amount of money that City of San Jose or Union City incurs is only relevant to the extent that they show costs of at least $1,000 for their claim, a whole test claim. So The exact amount is not that relevant at this stage.
Thank you. Any other questions, Ms. Greenross? Comments? No, okay. Any other comments or questions from commissioners in the room? Okay, all right, seeing none, is there a motion to either adopt staff's recommendation or a motion to?
I'll move to adopt staff recommendation.
I'll second that.
Okay. And we have a second, if we could please call the roll.
Mr. Adams,
Aye.
Ms. Clark,
Aye.
Ms. Gallegos,
Aye.
Ms. Greenross,
Aye.
Ms. Nash,
Aye.
Mr. Polland,
Aye.
Ms. Peralt.
Aye. Okay, that motion carries. We would like to ask the presenters participating remotely for item 2 to please turn off your video and mute your microphones.
Thank you for
And
your
then we
time,
will move
Commissioner.
now on to
Thank
item.
you.
Yes, thank you. And now we'll move on to item 3.
Next is item 3. The controller informed the commission staff that they do not intend to speak on this item, and the claimant did not provide any information about whether they would be participating in this matter. Senior Commission Counsel Eric Feller will please present a proposed decision and parameters and guidelines on disclosure requirements and deferral of property taxation, 22 TC 06. At this time, we invite the parties and witnesses to please turn on their video and unmute their microphone.
Eric?
Good morning. These parameters and guidelines are based on the test claim decision the commission adopted on July 26th of this year and the draft expedited parameters and guidelines issued on August 1st. The commission found the test claim statute imposes a reimbursable state mandate on only the County of Los Angeles for 2 categories of reimbursable activities. First, for them to process requests to defer property taxes filed by property owners over 55 or severely disabled or victims of a wildfire or natural disaster and who seek relief under Proposition 19 to transfer the taxable base year value of their primary residence to replacement primary residence. Second, to print summaries on each tax bill of the availability of Proposition 19 property tax relief and tax deferment procedures for properties that have been purchased, newly constructed, or changed ownership in the year before the tax bill. As Heather mentioned, no substantive comments were filed on the draft expedited parameters and guidelines. Staff recommends the commission adopt the proposed decision and parameters and guidelines with reimbursement period beginning September 28, 2022, and authorize staff to make any technical non-substantive changes following the hearing.
Thank you very much. We do not have comments from the controller, and it looks like we do not have any claimants here today. What's that?
Yeah.
Yes, and then if Ms. Yap from the Department of Finance, did you have any comments on this item?
Hi, Kaylee Yap, Department of Finance. We have no comments on this matter. Thank you.
Thank you. Okay, are there any public comments on this item before? There are none in the room. Are there any online?
Madam Chair, there are no public comments online.
Okay, seeing none, are there any comments or questions from members? Seeing none in the room, either online? Ms. Greenross, are you trying to unmute? Okay, excellent. Okay, then seeing no further discussion, is there a motion to adopt staff's recommendation?
Madam Chair, I would so move.
Okay, moved by Mr. Adams. Is there a second?
I'll second.
Second by Mr. Polland. If we could please have a roll call.
Sure. Mr. Adams,
Aye.
Ms. Clark,
Aye.
Ms. Gallegos,
Aye.
Ms. Greenross,
Aye.
Ms. Nash,
Aye.
Mr. Polland,
Aye.
Ms. Peralt.
Aye. All right, thank you. That motion carries. We'll now ask presenters participating remotely for item 3 to please turn off your video and mute your microphones. And we will go ahead and move on to item 4.
Commission Counsel Anna Barrett will present a proposed decision on California Assessment of Student Performance in Progress, or CASP, At this time, we invite the parties and witnesses for item 4 participating remotely to please turn on your video and unmute your microphone.
Good morning. This incorrect reduction claim alleges that the State Controller's Office incorrectly reduced reimbursement claims filed by Fresno Unified School District for costs claimed to implement the California Assessment of Student Performance and Progress Program, or CASP, which tests students in grades 3 through 8 and grade 11 in English language arts and mathematics using a secured browser-based testing platform. The claimant sought reimbursement for the purchase of new computing devices and broadband internet services to use for testing. The controller reduced the claim because it found that the claimant did not provide adequate supporting documentation that its existing inventory was insufficient to meet the testing specifications as required by the parameters and guidelines, and that the claimant's existing supply of computing devices and broadband internet services was sufficient according to a tool provided by the CDE and the testing contractor called the Smarter Balance Technology Readiness Calculator. Staff finds that the controller's reduction is correct as a matter of law. The state-mandated program does not require school districts to provide a computing device to every student, and the program is designed to be administered on older computing devices during a 60-day testing window, so that a district can comply with within its existing resources. Thus, to be entitled to reimbursement, the parameters and guidelines require a claimant to show with supporting documentation how its existing computing devices are insufficient to administer the CASP test to students based on the minimum technology specifications within the testing window identified in the CDE regulations. The claimant's documentation does not support that finding here. In addition, using an SBAC calculator to find the minimum number of devices needed was within the controller's audit authority and was not arbitrary, capricious, or lacking in evidentiary support. Accordingly, staff recommends that the Commission adopt the proposed decision and deny this incorrect reduction claim, and to authorize staff to make any technical, non-substantive changes to the proposed decision following the hearing. Thank you.
Thank you. Okay, just as a reminder, parties and witnesses will please state your name for the record. Mr. Kopowitz and Ms. Kellstrom for the claimants, would you like to begin?
Yes, good morning. Thank you very much. I'm appearing on behalf of the Fresno Unified School District. Also in attendance is Kim Kellstrom, Chief Executive of the Fiscal Services for the Fresno Unified School District. So this matter, unlike the previous agenda item, involves a test claim that has already been approved for reimbursement. After the parameters and guidelines were issued, and after the draft instructions, the claimant and other school districts submitted their claim for reimbursement. The district agreed with the controller's decision that disallowed the purchase of computer devices that was required by this mandate. This mandate changed the way testing was going to be done throughout California by requiring technology devices such as laptops, iPads, and other computer-related devices for all testing. After the district submitted their claim, the controller did an audit. In that audit, the controller disallowed the purchase of approximately 5,000 computer devices. This represented 15% of the total district's devices. The reason the district purchased these devices, which was anticipated by this mandate, was that they needed to provide devices for the testing of the students. This district has a population of over 67,000 students, which over 40,000 were tested through grades through 3 through 8 and number 11. What this mandate required was that testing was to be done over a 60-day period during the school year, which represented 12 weeks at 5 days a week. There was no requirement to do testing of a shorter period of time. What the district realized in they having a 60-day period would that be students would receive additional instruction if they had testing near the end of the 60-day period versus students that had testing during the beginning of the 60-day period. As a result, the district, in an effort to remove this inequities, selected a 35-day period. The controller admitted that there is no requirement to have 60 days and accepted that 35-day requirement was reasonable. The reason, again, for these inequities is that the district has a very high free and reduced lunch population of 90%, which includes lower socioeconomic students along with English language learners. Furthermore, the district is a large district. It includes a period of includes 95 different sites that needs to be tested, and it is over a geographical area of 6,000 square miles. Instead of, even with the 30-day, 5-day period, the district needed these devices to rotate among the 95 sites, which involves rotating computer on wheels, moving the devices through classrooms to different sites. As a result, as I mentioned, the district did need to purchase approximately 5,100 new devices. And for that, that is what they claimed in their reimbursement claim. It was considered during the parameters and guidelines process and during the test claim process that schools would need to purchase additional devices, and that when schools purchased them, it could be staggered. The district purchased them all in the fiscal year of 15, 16, 16, 17 for that testing. The guidelines that the controller used was referred to as SBAC. That's an acronym for Smart Balance, but there is no requirement that that be used as only the way to determine if the devices needed were necessary. In effect, the district contends that these one-time purchases were reasonable, that the 30-day, 35-day testing period was reasonable to remove the inequities, and as a result, they feel that the amount of the disallowance for the 5,100 devices was unreasonable and was not supported by the parameters of guidelines, nor was it supported by the documentation the district provided. The district did provide a total inventory of all the devices, and what they did is they backed out the devices they purchased for this program. So in effect, they had an inventory of the devices they had in existence before this program. Based on all that evidence, we feel that the incorrect reduction claim should be granted and the district should be reimbursed for the purchase of these devices. I myself and Ms. Kellstrom is available to respond to any comments or questions you may have. Thank you.
Thank you, Mr. Pankowitz. Appreciate that. Mr. Solis-Galiano and Ms. Alexander for Department of Finance. Do you have any comments?
Good morning, Commission members and staff. Hugo Solis-Galiano with the Department of Finance. We appreciate the staff analysis and agree with the staff's finding that the controller's reduction is correct. We concur with the recommendation that the Commission adopt the proposed decision to deny the incorrect claims reduction. I have with me my colleague, Amber Alexander, and we're happy to answer questions at the appropriate time if needed. Thank you.
Thank you. Okay, moving on, Mr. Howell for the State Controller's Office. Do you have any comments?
Not at this time. Ken Howell, State Controller's Office, Division of Audits. I was the audit manager over this particular engagement. So if anybody has any questions, I can certainly answer those. But we do agree with the proposed decision as well.
All right, thank you, Mr. Howell. Before I move to Commission members, are there any public comments? Seeing none in the room, are there any online?
Madam Chair, there are no online public comments.
Okay, excellent. Are there any questions from the members? Okay, Mr. Palmer.
So I have a question for Mr. Pankowitz. Does the district contend that it would be impossible for it to administer the tests without having bought new computers? I guess, let me rephrase that. Impossible to administer the test in compliance with state law without having purchased new computers.
I believe I would say yes, because of the discretion that they can do it on a shorter period of time. And so there would have been impossible to do it if they stayed with this.
But,
go ahead, I'm sorry.
But yeah, I guess my question is, you know, the state law gives you a certain amount of time, and I understand the advantage in a shorter time. I'm not questioning that component, but would it have been impossible to comply with the state law as written with the district's existing computer inventory?
I really can't comment on what's possible or what's impossible. The district made a decision on what was reasonable to comply with the state mandate. They have discretion in doing that. It's difficult to say, sir, if that would have been impossible or not.
Thank you.
Other questions?
No.
Okay, Ms. Clark, I see your hands raised.
Hi, thank you. I just noted that it seemed like in the briefing, there was a determination using this calculator by the controller's office that even using the 35-day testing window, it would still only require 4,215 devices within the existing inventory. And I just wondered if folks could speak to how that number, was generated and why that number is not sufficient, if that's the, appellate's contention.
Okay,
Mr. Howell, do you want to respond first, or Mr. Palkowitz? Go ahead.
Sure, thank you. So the smart balance technology, that was not part of the parameters and guidelines. They used that as an outside source, as using some determination. That wasn't discussed in parameters and guidelines, so there was no requirement to be used. Again, that even using that was just some type of guideline of criteria that is not to be determinative on what should be the amount of devices to be used. So unless there's a strict interpretation that must be followed, which I don't believe the controller admitted to in their audit. So I don't think that should be the determinative of what's going to be the amount of devices that are going to be allowed or disallowed.
Mr. Howell, did you want to respond to methodology, or also looking at staff here if there's a comment in response?
Yeah,
Mr. Howell first.
Oh, I'm sorry.
Mr. Howell.
Oh, yeah.
Go ahead, Mr. Howell.
One thing I did notice by going through and reading the decision, by using this approach, this kind of methodology, the commission actually pointed out on the top of page 56, if anything, this method of using this SBAC calculator overestimates the claimant's actual needs and gives the claimant its best possible chance at the controller finding the claimant's existing bandwidth was insufficient. So bandwidth,
to clarify, that was specifically for the issue of bandwidth. On using the calculator for the number of computers needed, that was a separate question.
Correct. Yes. The issue, but for our purposes, the issue of using that calculator actually served two purposes. One was to check their current. What we did when we initiated the engagement, we would always ask for that initial inventory list. From there, once we had that initial inventory list, it allows us the opportunity to go through and actually remove any computing device that doesn't meet the minimum specifications, and then kind of use that as the base level, and then determine, okay, based on the number of students, the number of students tested, the number of existing computing devices, would they have enough without needing to go out and buy additional devices within the mandated testing window, which is 60 days. Now, if the district chooses to use a shortened time window, they can do that, but that doesn't mean it's mandated. And therefore, that decision doesn't then mandate the requirement that they go out and buy additional computers to then meet that shortened time window to get all the testing done by the time the testing needs to be finished. So when we use that SBAC calculator, it was publicly available. It was actually districts. It was actually a design for districts to be able to use to assess their current inventory levels and to figure out if what they have on hand at the time is enough to meet the requirements of the mandated program. So we thought, okay, well, if it's available for them, it's available for us as well. Let's see if their existing inventory list, once we remove all, again, devices that are specifically for student use, let's figure out if that's enough. And by doing that, that's how we came up with the number of 4,000. So even even skewing the numbers to favor the district in the most advantageous way possible, they still only needed around 4,300 computing devices, but they had 31,000. So when you factor all of that in, it's like there's such a great disparity here. It's like they haven't been able to show us any evidence at all that they needed the additional computing devices to get the testing done within the testing window.
Thank you, Ms. Chow. Additional comments from staff?
I'll let Neil.
I was just going to circle it back to the parameters and guidelines and the decision on the parameters and guidelines. Those are binding on the parties. They are regulatory in nature, and the parameters and guidelines require that the claimants shall maintain supporting documentation showing how their existing inventory is not sufficient to comply with the minimum technology specifications, and that was not provided. So on that basis alone, you could deny the incorrect reduction claim. Here, the controller went further to actually see if they had a problem with the number of computing devices they had and the bandwidth on the internet, and they are allowed to use the calculator. The calculator was fully discussed in the commission's decision as a method to see if each district had sufficient materials to comply with the mandate. So you have enough information here on that. Thank you.
Thank you. Are there any other comments from commission members or? Yeah, I just want to comment and just reiterate for the record that while the claimant is using a 35-day test period, that is within their discretion, but that the 60-day requirement is still what is withheld, correct?
It's the maximum amount of testing time that they're allowed by the state. It's what they have to complete the testing within at minimum.
And then the only other thing I just wanted to just verify on that was there was a statement made that the purchasing window time period also seems to be an impact, that it was it was allowed for districts to stagger their purchases across, but they chose to do it in a compacted way. But again, that's a discretionary choice.
The purpose of the staggering is that school districts might find that their existing supply of computing devices are suddenly no longer able to use the 4 or 5 years out. They're no longer compliant with the testing requirements, so they need new computers to replace those old ones, that sort of thing.
Thank you. Okay, with that, unless there's other questions, I'm looking to see if there is a motion to either adopt staff recommendation or otherwise.
I'll move to adopt the staff recommendation.
Colin will move, and I will go ahead and second. If we could please have a roll call.
Mr. Adams.
Aye.
Ms. Clark.
Aye.
Ms. Gallegos.
Aye.
Ms. Green Ross.
Aye.
Ms. Nash.
Aye.
Mr. Pollan.
Aye.
Ms. Peralt.
Aye. Okay, that motion carries. We'll go ahead now and ask presenters participating remotely for item 4 to please turn off your videos and mute your microphones. And we will move on to item 5. Thank you again for participating, everyone.
Item 5 is reserved for county applications for a finding of significant financial distress or SB 1033 applications. No SB 1033 applications have been filed. Next, Program Analyst Jill McGee will please present item 6, the legislative update.
Good morning. The following are the legislative updates since the last time the commission met. The last day of the 2-year legislative session was August 31st, 2024. The governor must sign or veto all bills that passed by September 30th, 2024. First, AB 1781, state mandates claims. This substantive spot bill would have changed the minimum mandate reimbursement claim amount from $1,000 to $800. This bill did not pass before the end of the 2-year session and is now dead. Staff will continue to monitor legislation for bills that impact the mandates process. Thank you.
Thank you. Move on to item 7.
Next is the Chief Legal Counsel report. Camille Shelton will please present item 7.
Good morning. There have been no new filings, no recent decisions. We did participate in oral argument a couple of weeks ago on September 13th in the City of San Jose versus Commission on State Mandates case dealing with the remand of lead sampling. Thank you.
Thank you. All right, Heather, the Executive Director's report.
This is an action and an information item. And first we will take up the action item, which is the proposed 2025 commission hearing calendar. Commission meetings are generally held on the fourth Fridays of odd months unless they conflict with a holiday. In 2025, the Thanksgiving holiday conflicts with the commission's regular hearing date. The May hearing is proposed for the Friday of Memorial Day weekend as usual. And therefore, all but one of the 2025 regular meetings are proposed for the fourth Fridays of odd months. In addition, tentative hearing dates are proposed for April 25th, 2025 and October 24th, 2025. Staff recommends the commission adopt the proposed 2025 hearing calendar.
Thank you, Ms. Housley. Are there any questions or comments from the commissioners? Okay, seeing none online. Is there a motion?
Madam Chair, I'd so move.
Okay, moved by Mr. Adams. Is there a second?
Second.
Second by Ms. Nash. If we could please have a roll call.
Mr. Adams?
Aye.
Ms. Clark?
Aye.
Ms. Gallegos?
Aye.
Ms. Green Ross?
Aye.
Ms. Nash?
Aye.
Mr. Polland?
Aye.
Ms. Peralt?
Aye. Thank you. That motion carries. And now if you want to provide us the informational portion of your report.
After this hearing, there are 37 pending test claims, 35 of which are regarding stormwater. There are 1 parameters and guidelines and 6 statewide cost estimates and no IRCs pending. Commission staff expects to complete all of the currently pending test claims by approximately the May 2027 commission meeting, depending on staffing and other workload. However, some of the test claims may be heard and decided earlier than currently indicated if they're consolidated for hearing. And that is all I have.
Are there any questions on the report? Okay, seeing none. Okay, well, before we move into closed session, unfortunately, it is our executive director's last full hearing. And in honor of her departure, we didn't want to conclude our open meeting without acknowledging all of the wonderful work she has done for this team. Ms. Housley has been with this team for a very long time, and I know that they are going to miss her. All the while, we still obviously wish her the best in retirement. But before we do that, and Heather, you're not here, but we do have a resolution that we will present to you. The staff will get it to you at sometime after the meeting. But before we move into closed session, I would like to just go ahead and read the resolution into the record, and then if other members have comments that they'd like to provide, we'll go there. So, but bear with me while I read this. A little bit on the lengthy side, but in honor of Heather Housley, Executive Director for the Commission on State Mandates from 2008 to 2024. Whereas Heather Housley has been with the Commission since 2008, starting as a senior staff counsel and was appointed Executive Director in March of 2012. And whereas prior to serving as staff to the Commission, Heather was senior staff counsel for the Department of Healthcare Services, an associate attorney for the law firm of Hatch and Parent, a committee consultant for the Assembly, and staff counsel and legislative analyst for the Governor's Office of Planning and Research, where she served as a member of the Commission from April 2000 to May 2002. And whereas Heather, as Executive Director, established internal processes for the timely completion and review of test claims, incorrect reduction claims, and other matters pending with the Commission, and oversaw amendments to the Commission's regulations to streamline the process for these matters, which resulted in the reduction of the backlog that existed when she was appointed, including a backlog of 141 incorrect reduction claims. And whereas Heather quickly and successfully transitioned Commission staff to working remotely during the COVID-19 pandemic, including remote and hybrid public hearings of the Commission, kept staff informed, and implemented policies and procedures to protect the health and safety of commission staff, resulting in no commission staff outbreaks. And whereas Heather kept staff on task and urged them to follow the process and at the same time encouraged the attorneys to enjoy stormwater claims and urged them all to take vacations, exercise, and have fun. Now, therefore, be it resolved that the Commission on State Mandates warmly congratulates Heather Housley on her retirement and wishes her days and nights filled with travel, warm beaches, good authentic food, and music. Done this 27th day of September, 2024 in the County of Sacramento, State of California, in witness thereof by the Commission on State Mandates. Thank you so much, Heather, for everything you have provided to not just the commission members, but I know your staff and your team. And we wish you the best of luck and relaxation in your retirement. So with that, are there any other comments from commissioners on this item? Mr. Ross?
Thank you, Madam Chair. Heather, I just want to say all the best in all future endeavors. I can't believe that I've been sitting here 6 or 7 years, and it seems like just yesterday that I sent you a picture of Halsey Hall at Annapolis, and you called me on the phone and said, "What the heck are you doing there?" Named after Grandpa. So again, congratulations, and I will miss you very much.
Yes, of course. Go ahead, Christine.
Well, Heather and I have been working together in some capacity for almost 20 years, which is unbelievable. She's one of the hardest working people that I know. When she came here, as we indicated in the resolution, we had a huge backlog of test claims and incorrect reduction claims. And to Heather's credit, she really did establish and develop internal processes and procedures to address that backlog. She held up and was responsible for streamlining the commission's regulations so that the process got rid of duplicate stages in the hearing process. We now have draft expedited Ps and Gs. Thank you to Heather. But the internal processes really helped me with my review of all the items that went before the commission. We were able to stagger things and it became more seamless than crazy right before commission hearings. So that's a huge accomplishment, Heather. I think you've done a great job and we're really going to miss you. So congratulations on your retirement. Others?
Mr. Paul?
Yeah, certainly. I've been here a very short period of time, and I've only seen what goes on every other month and missed most of the day-to-day. But in my very brief period here, it seems that you've left a very indelible mark on the Commission State Mandates, and it's clear your steady hand is taking an organization that was perhaps in some disarray and created a very smooth, well-running operation that does extremely important work. So I'd like to express my thanks as board member for your service here.
Thank you so much.
Well, thank you, Heather. Again, we appreciate it, and I know you will be missed greatly. So as I said, we have a fancy version of what I just read to get to you, and the staff will make sure you receive that. So again, thank you.
I just want to say,
okay. Oh, go ahead.
I just wanted to say how thankful I am to the commission for appointing me to the position of executive director, giving me their trust, and also giving me countless opportunities to grow personally, professionally over the years. And I will miss the support I've received from the entire commission staff throughout my tenure as executive director. Each of you has contributed so much to the commission's achievements over the past 12 years. And I look forward to watching you all continue to grow, and I wish you all continued success in your careers and beyond. Thank you.
Thank you. Okay. With that, we are going to go ahead and recess to closed session. The commission will meet in closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The commission will also confer on personnel matters pursuant to Government Code Section 11126A1 and we will reconvene in open session in approximately 15 minutes.
Eve? Right, did you guys get your link for closed session?
Okay, and I'm just waiting for 2 members. So logging back in here, give us a moment.
And Madam Chair, I'm hearing a bit of an echo, so I don't know if anyone has their audio on.
My end, it looks like everybody's muted. Is it still echoing?
Yeah, everyone is muted. Someone must have their speakers on.
Okay, is that better?
Yes.
Did we fix it? Okay, great. Okay, thank you. All right, so we'll go ahead and reconvene into open session. The commission met in closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. Commission also conferred on personnel matters pursuant to Government Code Section 11126A1. So with no further business to discuss, I would like to entertain a motion to adjourn. So moved. Moved by Ms. Nash. Wait a second. Nobody wants a second?
I will second.
Second by Mr. Adams. We'll please have a roll call.
Mr. Adams.
Aye.
Ms. Clark.
Aye.
Ms. Gallegos.
Okay, aye.
Ms. Green Ross.
Aye.
Ms. Nash.
Aye.
Mr. Pollen.
Aye.
Ms. Peralt.
Aye. And with that, we will go ahead and adjourn the Commission on State Mandates at 11:54 a.m. Thank you, everybody, and we'll see you at our next meeting.
All the best,
you.
Heather.
Yes.
Thank you. I'll see you in
Congratulations
October. Thanks.
Okay.
Bye.
Congratulations, Heather.
Thank you.